Hey guys, Whitney here, and I'm joined by my lawyer, Jarom Bergeson. I am so happy to have him here. We are going to just give everybody just a minute as people file in the room. I'm expecting a pretty big crowd today, so I don't want to take off on the presentation and leave a bunch of people behind. But yeah, as you guys are filing in, I know I've done these presentations. Jarom and I have done a couple of presentations before with real estate investors. We tend to get a lot of very specific questions to people's specific situation. That is probably not the focus of today's conversation. However, if you have a general question, make sure you find that chat box, raise your hand. I will do my best to moderate questions, get as many in as we can in the time that we have allowed. Definitely feel free to ask those sorts of things. Don't be surprised if we say, gotta schedule a consultation or talk to your own legal team. Anyways, let's see where we're at. All right, I think we still have a couple more people filing in, but we'll go ahead and get started just for time's sake. So guys, thank you. Whitney here. In case you missed that, I am the Director of Investor Education here at PassiveInvesting.com. And I am so thrilled to have you here with me today and in our conversation with Jarom Bergeson. He is my own personal lawyer. He's been advising me for, I don't know how many years. Years,
for sure.
Many years. So he has helped me navigate so many different waters and helping me actually make some very smart moves to scale both my active portfolio, my own personal business, as well as my passive portfolio. And guys, we're going to focus on the passive portfolio today. But before we get started, if you guys like this content and information, you want more of it, make sure to go over to PassiveInvestingWithWhitney.com. Make sure that you're on that list to get some freebies that I have for you, but also that so you can hear about future episodes that we do here on the Passive Investing Made Simple show. Anyways, I'm going to do a brief introduction and then turn it over to Jarom to kind of fill in the gaps for us. But, Jarom's focus is working with entrepreneurs and real estate investors, hence the reason why he and I are such a match made in heaven. But really helping real estate investors think through taxes, how to protect their assets, even how to raise business capital, and just navigate all these different complexities with self-directed monies in their environment, in their retirement accounts. And actually helping you put together strategies to protect these assets and pass them on to the next generation. So, Jarom, I'm going to turn it over to you just to kind of fill in the gaps there.
Yeah, I think that's pretty accurate. I am a licensed attorney in Colorado, Utah, and Nevada, and we focus on tax minimization, asset protection, estate planning, and then sort of definitely sprinkle in self-directed retirement account investing. So people who want to invest their IRAs and 401ks and things other than stocks, bonds, and mutual funds, including passive real estate, syndications, that sort of thing, all kinds of frankly crazy stuff that we help people invest their retirement accounts into. But I've been here with KKOS Lawyers, this firm here for about 10 years, a little bit more than 10 years, focusing on this. I try to stay out of the courtroom and help other people stay out of the courtroom. That's a big part of my practice.
Awesome. And I know you're particularly licensed in those states, but are there, with KKOS, do you guys cover all 50 states?
We do. We have clients in all 50 states. And I can't appear in court in any of the states other than Utah, Colorado, and Nevada. And I'm actually inactive in Nevada, so I couldn't even do that there. But we do planning, asset protection, tax planning, estate planning in all 50 states.
Awesome. Well, great. Thank you so much for filling in the gaps there. But yeah, just kick us off. How did you get started? I mean, way back in law, but more importantly, in focusing, working with real estate investors.
Yeah, I mean, I've always been interested in that part of the law, and especially in business law, and lots of business owners, their business is investing in real estate, and then they maybe have other parts of their business. So I've always wanted to work with entrepreneurs and focus on sort of the transactional part of the law. I didn't expect to go to law school until about a year before I went. I wanted to talk about sports for a living. And so I got a broadcast journalism degree and worked for a radio station, and they wanted to hire me at, I believe at the time it was $7.50 an hour to be a producer on a radio show in Salt Lake City for sports. And I decided I needed to do something else. So I got into law school, never wanted to do criminal or divorces or DUIs, sort of always wanted to focus on the business end of things. My dad was a small business owner for a while and worked in the corporate world. And that's sort of what I always wanted to do.
Awesome. Awesome. So let's kind of kick it off. Like, what are some of the benefits that that investors have, limited partner investors have when they invest in syndications? What should they know about?
Well, I mean, the benefits obviously are mainly financial, right? You're investing into something that you don't have to put much, if any, work into. You're letting your money work for you, obviously, in a passive investment. And so from a legal standpoint, that means I'm putting money in and I'm hands off. And in most of these syndications, whether you're buying into a limited partnership or an LLC, you have limited, that's why there's limited in the name of both of those entities. You have limited liability for what happens on that piece of property. So when you invest into a syndication and you're not making decisions and you're a limited partner, if something bad happens out there that causes the property owner to get sued or the business to get sued, it's the business that gets sued, not you personally. So you have protection from the liabilities out there affecting your personal assets. What you own isn't going to almost ever be at stake because something crazy happened out on the property. Whereas if you own a piece of real estate in your name, somebody trips and falls out there and wants to sue the property owner, your assets can be at stake.
Yeah, definitely. I know we've done extensive planning because we have active properties or properties that we own personally, and then also passive investments. And it just takes the amount of work that we put into focusing on how to protect ourselves, like my husband and I, like from our active assets, is nowhere near what we do for our passive stuff.
Right.
So what are some of the legal, maybe implications or drawbacks for that investors should know about, limited partners should know about when investing in, say, like a syndication or a fund?
Right. So when you invest into a fund or into a syndication deal, you are trusting, right, your money with somebody else. That money's going away. You don't have control of it anymore. And so you need to do a lot of due diligence as to who is it that I'm investing with? Who are these people? Do they have a history of doing this? Have they jumped through the right legal hoops to be able to do this time? And so that's things like, right, in a syndication deal, for example, there should be a lot of legal disclosures to you. You should be getting something called a private placement memorandum or a private offering memorandum that sets forth, here's what we're doing with your money as an investor. Here's the terms upon which you're going to be repaid. How are you participating in profits that are generated by the project? What are the potential liabilities out there? A good private placement memorandum takes a lot of space and a lot of time warning you about the ways your money could be lost, right? That's what we're doing. I do these, right? And it's a gigantic CYA document, right? We're trying to cover our clients behind when they're raising money. And so part of that is we want to tell people, hey, there are risk factors here. The market could go south. There could be issues with, construction, that sort of thing. There could be a worldwide pandemic that slows things down. Now, we didn't used to put that in, but now we do. So those sorts of things, and conflicts of interest. You want to have a document that goes through those things so that you can make an informed decision. So beyond what's also, just real quickly, beyond what's in that document is when people are taking money as an investment, they're selling you something called a security from a legal standpoint. And so in order to sell you a security, they need to be jumping through some sort of legal hoop. Either they register the security with the Securities and Exchange Commission, which is rare for the types of deals we're talking about, or there is a set of rules that are exemptions to that requirement. And in that document, you need to see, hey, what exemption are you relying on here to be able to take my money? If I'm not an accredited investor, and I don't know if we want to talk about that here, but if I'm not an accredited investor, there's a very much smaller window of exemptions than if I am an accredited investor. So you want to make sure they're dotting their I's and crossing their T's from a securities law standpoint, because if they're not, and they get investigated by the Securities and Exchange Commission or a state securities regulator, that can tie up your money, right? Your money is in there, and now they can't do what they were going to do because they're completely focused on dealing with an investigation by the SEC or State Securities Division. So, it is in sort of investor beware. There are lots of potential pitfalls on the front end. Most people aren't committing fraud. Most people aren't out there running Ponzi schemes, but there are places that they can get tripped up that can cause you problems.
Mm-hmm. Definitely. I know here at passiveinvesting.com, we are the regulation that we, or the exemption that we take is under Regulation D. So we're mainly operating with 506C investors. Doing 506C investments, meaning we're taking primarily accredited investors into those investments. But I'm going to make one comment there, but I want to pivot back to something you said. A resource that I tend to give investors to look up to see if an operator has actually filed that exemption under Regulation D is to go to formsd.com.
Yeah.
Very simple. And you have to actually, you might be able to look it up underneath the operator's actual name, here in case here would be like Danny Hanford or Danny Randazzo, Brandon Abbott. But you can also look it up under the entity's name that is investing. So one way or the other, or both ways, will actually get you that information. And that's something that I do. It's on my due diligence checklist, and I suggest everybody have it.
Absolutely right. If it's, hey, you're going to make an investment in XYZ LLC, you can go to that site. There's actually a government site called Edgar, EDGAR.gov, where you can look up and go, okay, have they filed the necessary paperwork with the SEC? And if you don't see it, then that's something you need to make sure either is going to be filed, and you want it to be filed before you invest. That way, they're jumping through those hoops.
Yeah, definitely. And just to repeat it, because I know people are asking me in the comments to repeat it now. Everybody that's watching this later on YouTube is going to ask me to repeat it again. FormsD, D as in dog.com. And then there was another site, the Edgar site.
Yeah, the government site is ED as in David, G as in golf, AR. I think it's just edgar.gov. If you Google Edgar, EDGAR securities, it'll come up.
Awesome. Thanks so much for that. But let's go back and just redefine for everybody here. And before we kind of go back down into the regular questions that investors have about the legal implications, let's define the difference between an accredited and sophisticated investor for everybody.
Yeah, an accredited investor, there are two main ways to qualify as an accredited investor, either through your income or through your net worth. And when you hear accredited, you go, well, I must have to know something. No, the SEC doesn't really care that you know anything to be accredited. They care about your ability to absorb losses. So if you make as an individual more than $200,000 a year, or as a married couple $300,000 a year, and you have for 2 years, and you expect to in the current year, you have a reasonable expectation to, then you qualify as an accredited investor based on your income, and that's your adjusted gross income. If the other way is your net worth. If you have a net worth in excess of $1 million, not including the value of your principal residence, so the equity in your house doesn't count towards that $1 million. But if you have a net worth north of $1 million, that's the other main way to qualify as an accredited investor. You can have certain securities licenses now and qualify as well. But the main ways are through net worth or through income.
Awesome. And there was a definition change. It used to be married, but now it's communal partner, correct?
Correct. Right. I think domestic partnerships count. Obviously, any marriage counts as well.
Awesome. Now, okay, so we defined an accredited investor. If you're wondering if you are an accredited investor, one of the things that I suggest people do is you can go either talk to your lawyer or CPA to see if you can get a letter from them. Sometimes that's costly to do, maybe not. But also there are third-party resources out there like parallelmarkets.com to where you can go on and, generally it's a broker dealer that is verifying, your income or your net worth for you on your behalf.
Yeah,
so,
and I'll just say this: people will ask me to verify or write that letter that they're an accredited investor. Maybe it's because I'm an attorney. I don't like doing it. I don't do it very often at all. Plus, I'm expensive, right? Per hour to draft that, to get that verification done, because I'm going to have to pour through your stuff because I don't believe you, right? I'm an attorney. I have to verify. If I'm going to put my name on that and attach myself to some potential liability, I better know that you're an accredited investor. So I would advocate for using those third-party services. Your attorney or your CPA can do it too, but they're probably going to be pretty expensive.
Awesome. So let's pivot to a sophisticated investor.
Right. Sophisticated investor is a much more squishy term. There aren't a lot of great definitions for it. It just means that you have enough knowledge based on your experience, or you have an advisor who has enough experience to make you otherwise sophisticated with these types of investments. So if you've worked in these industries, if you are an expert in real estate, then you can qualify as a sophisticated investor. And so there are some offerings that are for accredited investors, and then a certain number of sophisticated investors. There's not such a bright line with sophisticated as there is with accredited.
Right. And typically the offering exemption that you're looking for is 506B, but just because it's a 506B doesn't mean that they have to take a
sophisticated investors.
Yeah,
no. In fact, I don't like it when my clients that are on 506B take non-accredited investors, even if they're otherwise sophisticated. There's language in there that says that you can do that, but you have to give them extra disclosures that are usually really expensive to come up with, and that I don't do. So no, you don't have to, right? If you're in 506C, everybody has to be accredited. If you're in 506B, you can on paper take up to 35 non-accredited investors, that are otherwise sophisticated, but you don't have to. And I advise people not to, frankly.
So what kind of protections does that provide the actual investor, knowing that everybody in the investment's accredited?
I think, well, it helps in that the issuer doesn't have to do all those additional expensive disclosures, number one. So the money you're investing is going towards the investment, not towards additional legal and accounting costs. That's helpful. It also kind of not 100%, but to be honest, accredited investors tend not to complain quite as much. They're not as hard to deal with. They're not such a drain on the time of the people making the issuance, and so it sort of evens the playing field. There's not going to be people that are like, I put every last penny I have into this, and they're kind of a time drain for everybody else involved.
Okay, so maybe like a different way to phrase it is, you kind of going back to that definition, the Securities and Exchange definition is that, if you can qualify as an accredited investor, there's more potential that you could absorb a loss or a disruption if one should occur.
Right.
Okay.
Right.
Awesome. So just having, worked in the investor relations field for so long, there, I get so many questions from investors on the phone. And I really, part of me bringing you on today is to field some of these specific questions in a more general audience. But one of the big ones that I get asked, especially in an introductory call, is like, how should I title my investment? Should I hold them individually, jointly, in an entity? How does somebody kind of work through that decision-making process?
Yeah, and you do need to work through it, right? So the simplest thing, right? If your main goal is to do this as easily and cheaply as possible, then if you're going to invest into a fund, into a syndication, you would just do it in your own name, right? That's the easiest thing to do. It's not necessarily the best thing to do, but it's the easiest and it's the most common. It really is. Potential drawbacks of that. Well, this might be a time to share my screen. Are you all right with that?
Yeah, let's do it.
All right, because I've got a little diagram up, and when we work with clients, we will put together diagrams that look a lot like the one I'm about to show you here, to sort of help people visualize how they might do something. So let me hit the magic button, hopefully. All right. So hopefully you can see that. You can see my cursor going along there. So this is what you're looking at here is a potential. It's an example of a passive investment structure. On the left-hand side would be the investments you would make with retirement dollars if you were going to do that. And over on the right-hand side is how you might structure it with taxable income, with non-retirement dollars. So if you're going to title something in your own name, you're going to title the investment in your own name, none of this would exist, right? There would be an arrow from your name up to the syndication offering entity, whatever entity is, making that offering, and you just invest in it personally. Drawback number one of that is, well, what happens to that asset? Because it is an asset, it's an ownership interest in an LLC or a limited partnership. What happens to that asset when you die, right? If something happens to you in the meantime, what happens? Well, it's in your name, you're deceased. So if you have a will, your will is going to say who gets that asset. If you don't have a will, then the intestacy statute of the state where you live, so the state legislature of whatever state you live in, has passed what are called intestacy statutes that say who's going to get that asset. But those people are going to have to, whoever's supposed to get it, whoever your heirs are, either way, with a will or with or without, they're going to have to go through something called the probate process to get that asset out of your name because you're deceased and into theirs. So that's where the bottom part of this diagram comes in. So then the next most complex structure would be, let's set up a revocable living trust and let's title that syndication, ownership. Let's have an arrow going from the blue box here up to this purple entity. So I own that in the name of my trust. You could do that. That would be sort of the next structure up. Now, when you own that asset in the name of the trust and you die, the owner of the asset is the trust and the trust isn't dead, right? You've named in that trust a successor trustee or trustees, and they're vested with the authority to distribute that asset as you direct in the trust without anybody having to go through the time and the expense and the headache of the probate process. Does that trust provide any additional tax benefit? Nope. Does it provide any additional asset protection? Nope. It's just there to avoid probate. In the structure I have here, the trust would own, so you would have your trust. Your trust would own 100% of an LLC in a state like Wyoming that has what we call charging order protection. And I'll get to what that is here in a second. But it would be this LLC, this what I called syndication investment LLC, would be the entity that's going to invest in syndication 3, syndication 4, syndication 5. So you're titling, to answer, that was a really long way to answer your short question, Whitney. You would title that investment in the name of that syndication investment LLC. Does that make sense? I'm sorry, I know I'm talking about.
Yeah, it definitely makes sense to me. And One of the things, and this was something that you and I in our work together ran into a few months ago, is that I felt like that, and maybe I'll just pose the question to you. Is there a sliding scale of which somebody should think about implementing some of these strategies?
Right. So the purpose of this, of the syndication investment LLC, is to make it as hard, well, not as hard as possible, but almost as hard as possible for someone to be able to get at your ownership interest in the syndication because they have a judgment against you personally, right? You get in a car accident or something like that. Somebody sues you personally and they win the lawsuit. The accident was your fault. They're coming after your assets. They got all the insurance money, and maybe their judgment is bigger than that. So they're coming after your other assets. Well, in this structure that I have here, what's your asset? It's not the buildings up here, right? It's not the real estate. It's not even your ownership in the syndication fund deal. Your asset is this Wyoming LLC. That's what you own. And so this charging order over here means that if somebody wants to get at what's in that structure, all they can get is a charging order against that LLC in Wyoming. And the charging order says, hey, if this LLC, which is the blue one there, ever makes a distribution out to me, to Whitney, whoever's the owner through their trust, they get to step into your shoes and take that distribution. But they can't force the company to make a distribution, and they can't force the company to liquidate assets so that they can get paid. So it's just this game of chicken with them going, well, you got to make a distribution sometime, and you're saying, no, I don't. So to answer your question, the more likely you think it is for you to be sued in a way that's not covered by insurance, or where there's some huge judgment that exceeds the policy limit, the more sense this makes. It's also providing some protection the other way, right? Somebody slips and falls out here, something happens on one of these pieces of property, and Syndication 3 LLC over here gets sued. It provides limited liability to the owners, right? Which is you or your trust if you don't use this blue LLC. But if something happens that causes Syndication 3 offering LLC to get, for its corporate veil to get pierced, maybe they were commingling funds and not keeping the LLC's bank account separate, or they didn't do filings they were supposed to do. Now it's at least theoretically possible that the owner's assets could be at stake in that lawsuit. So having the blue syndication investment LLC also provides an additional layer of protection for your personal assets from what might happen out on these properties. So the riskier you feel like maybe the real estate investment is, and the more likely you feel like it is that you could get sued personally in a way where these assets could be at stake, the more sense a structure like this makes.
Okay. And the question came in, and this is something that I can help people field is, okay, maybe I have my asset already titled to my personal name or to my trust, and I want to move that title. Like, can you do that? Yes, you
Right.
can.
Right.
Now, I also have to put an asterisk by it. Check the operating agreement and check with the operator, because there may be some finagling there that needs to happen, but most operators that I know will help accommodate that. Now, there is a cost, because now you're doing a legal change of title. You have to have, there has to be a lawyer involved with that in most cases, and so it's not the cheapest thing to do, but it can be done.
Yes, you can sort of almost always, and you're right, you need to talk to the issuer of the security and see what the operating agreement says. And in most cases, they're not going to have a problem with it. But yeah, you should be able to do it, but there will be costs involved. So it's better, if you can, to plan ahead and have the structure set up ahead of time. That's not always possible, but if it is, then you want to do that.
Awesome. So we talked a little bit about, like, individually, we didn't talk about, titling it jointly with the spouse. Is there any considerations that we need to have there?
From an asset protection standpoint, so from a tax standpoint, as long as you're married filing jointly, it won't matter. From an asset protection standpoint, if we're not going to put together a structure like this, then we might think about titling the asset in the name of the lower risk spouse, right? So if there's a spouse that is a doctor, doctors tend to get sued for malpractice, right? So we might want to title it in the name of the other spouse who has a lower risk job or is a stay-at-home mom or dad or whatever. So there can be considerations that way. Now, my divorce attorney friends would say that's a dangerous road to go down for the spouse that's not on title, because then the presumption, you can overcome it, but the presumption in a divorce is, well, that's not yours. That wasn't yours. That was the other spouse's. Now, in a community property state, there's all kinds of, and I'm not a family attorney on purpose. I don't want to be, but there are considerations for that as well.
Awesome. So what about the retirement structure that you have over here, the retirement asset structure?
Right, which is something I don't know how exposed the folks we're talking to are to this, but you can make these types of investments with your IRA. Or if you have your own business or you're self-employed in some way, maybe your own solo 401k. Or if you've got money in an old employer 401k and you want to roll it to an IRA. Your retirement account dollars don't have to be in the stock market. Now, if that's where you want them, great. And I have to throw a disclaimer as an attorney. I always have to throw a disclaimer somewhere. I'm not giving you any investment advice here. I don't know what you should invest in. I'm not telling you what to invest in. But if most people have no idea what a good mutual fund is to invest in, but a lot of people that I talk to know a good real estate deal when they see one. So if you wanted to use retirement account dollars to invest in a syndication or a fund like this, then that's the structure over here on the left-hand side. Your trust doesn't own an IRA, right? The I in IRA is individual. So that IRA belongs to you, but you can make your trust a death beneficiary so that those assets go where your trust tells them to go. But you would have an IRA, a self-directed IRA, and that just means an IRA at a custodian, an IRA custodian that will allow you to make investments outside of the stock market, right? An account at Fidelity, you got to stay in the stock market. An IRA at Fidelity or Schwab or Ameritrade, you have to stay in stocks, bonds, and mutual funds, exchange traded funds. But a self-directed IRA custodian will let you go invest in anything that's legal for IRAs or retirement accounts to invest in. And the only things you can't invest in are life insurance and collectibles. So no baseball card collections or wine collections, but real estate, sure. Real estate syndications, absolutely. So your IRA can invest in those directly. I like to have an intervening, what we call an IRA LLC. That's the green entity here. So your IRA owns 100% of an LLC. You're the manager of that LLC. So now you're effectuating all the transactions on behalf of that LLC instead of having to go through this custodian middleman to sign documentation anytime you want to do something. So that's what that green entity there gives you, sort of checkbook, what we call checkbook control over your funds. But then that LLC would go and invest in these syndication offerings, the various limited partnerships or LLCs that you're going to go invest in that are investing in real estate. And obviously the reason you do this with retirement account dollars is unlike over on the right-hand side of the page. On the left-hand side of the page, when there are profits that come back to that green LLC, do you pay taxes on the profits? Nope. Not at any, well, not at any point, but not when they're, a property sells and they do a big distribution out to the investors. Do you pay taxes? No. The rents are, way up and you're making a bunch of money on rents and they're making those distributions. Do you pay taxes? No. The only time you're paying taxes in an IRA is when you take money out of the IRA in retirement. Unless it's a Roth IRA, then you don't even pay taxes then. So there are tax advantages, obviously, to making investments with retirement account dollars.
Awesome. So, we had Scott Maurer on from Advanta IRA, and, he touched a little bit on this. We didn't go so much into like the checkbook control type of strategy, but we did bring what came up in the conversation was a court case that came down in December, McNulty versus Commissioner.
Right.
And would love to kind of gather your thoughts on like, do you see any extension of that court case affecting checkbook control?
We don't, in really much of any way, shape, or form, right? The holding of that case is that people that want to invest in precious metals with their IRAs or their IRA LLCs can't physically possess those assets, right? You can't keep your gold or your platinum that your IRA or your IRA LLC owns at home. That's that, and we've always said that. There are people that are trying to extrapolate out that, well, they talked about you have too much access to your own assets, and that is what they talked about. But there was an IRA LLC involved in that case. It wasn't just theoretical. So if the court had wanted to say, oh, and by the way, you can't even have an LLC that's owned by your IRA, they could have. They didn't. So we're not concerned really at all about that case making it so that checkbook IRAs or IRA LLCs are illegal. There are some things, I'm not going to get into this because this isn't, we're not talking about crypto. There are some things people do with cryptocurrency assets that with IRAs and IRA LLCs that I could see there being sort of an analogy made, but not with the form of a checkbook IRA or an IRA LLC itself.
Okay. And just for everybody's benefit, I mean, we touched on a couple collectibles like baseball cards and wine, and I can totally see why the IRS doesn't want us investing in wine. For me, I would probably crack open a bottle and consume it.
That's actually where the law comes from. That's where it comes
from. But what other things fall into that collectibles category?
So it's a lot of times precious metals, right? Coins. There are certain types of coins and precious metals you can invest in, but just a valuable coin collection, no. Classic cars, can't do that. Those are some of the main things. There is wine collection, artwork, right? You can't invest in artwork, even though that might be a great investment. The IRS and the Department of Labor said you can't do that with retirement account dollars.
Is it because you get to enjoy the asset?
That's part of it. That's part of it, and I think another part of it is that it's just, I think the IRS saw it as being, and not just the IRS, but the legislature, the Congress just saw it as being too volatile and risky. It is also that you get to, you can have personal enjoyment of, the artwork. You can hang it in your home. That or baseball cards, you can go look at them in your collection, that sort of thing, and go, this is cool that I have that. You're not supposed to get any personal enjoyment or personal benefit. Enjoyment's the wrong word. Personal benefit from your IRA's investment. So like in real estate, in this structure here, we talk about investing in syndications. But can that green LLC just own a rental property? Yeah, it can. It absolutely can directly. And you can make income that way. But you don't ever get to go stay on that property. I've had people that want to do that, right? I'm going to buy a vacation rental with my IRA. Can I do that? Yes, but you never get to stay on it. I've had people that go, I'm going to stay there a week out of the year. No, you're not. You're not, your spouse isn't, your kids and grandkids and their spouses and your parents and grandparents get no benefit from that property. Or a property you want to fix up. Can you fix it up? No physical labor to improve or maintain a property owned by your retirement account.
Good to know. Good to know. Now, and I'm going to ask this question because it's one that we get every time when we even like open up the door of retirement and taxes and we put the two in the same sentence. What about UBIT? Like, is that a concern at all here?
Not on the passive side of things. And so I do need to make sure I qualify that. So in a syndication deal, right? Let's say my IRA, either directly or through an LLC, is going to invest in a syndication deal. If the syndication deal is, we're going to buy an apartment complex, fix it up, and then rent it out for years and years, and then, we might sell it down the road. Well, that's rental income. Rents, royalties, capital gains, interest, and dividends are the main sources of passive income. And when your IRA invests in a source of passive income, there's no UBIT. But if it was, well, the fund is going to go buy properties to fix and flip homes and do it over and over and over and over and over again, dozens of times a year. Now, even though you're passive, right? Your IRA is not going out and swinging a hammer. You're not going out and swinging a hammer. But because it's an active trade or business, now, yes, the profits that come back to your IRA would be subject to UBIT, or you buy into a startup company. People do that all the time, like an app or something like that. We're going to sell, get a bunch of money from selling this app. That or a McDonald's franchise, anything where the end business is performing a service or selling a product, or in the real estate realm, it's short-term flips or land development. We're gonna subdivide and do a bunch of work on a piece of property and sell off the lots. Then that very well could be subject to UBIT. And sorry to get a little technical, regardless of what the fund is doing in real estate, if the fund is going to borrow, right, it's raising maybe a down payment and then it's going to borrow money to from a bank or whatever to finance its activities, then a portion of the profits is going to be subject to something called unrelated debt financed income tax, or UDFI for short.
Awesome. Okay. So normally I don't go too far down the rabbit hole, because again, this is one of those questions that is so individualized, and you really need, please do not take anything from this webinar, without taking it back to your own accounting and legal team before implementing. Okay.
Yeah, that's my other disclaimer is I'm not giving you specific tax or legal advice for your situation. So yeah, always run anything. If something sounds interesting and you want to talk about it with us or your own advisors as to your situation, that's absolutely do that before you do any of this.
Definitely, yeah, because I've got a lot of questions coming in that are individualized. And guys, at the end of this, for those of you who are here live, we're going to stay on for a couple minutes and kind of tackle some interesting Q&A to kind of percolate some thought. But I want to move us on, because whenever you were showing your diagram and we were looking at the COPE strategy, okay, the charging order protection strategy, is there something, what do people have to take into account as far as bookkeeping and banking and stuff like that?
Right. And especially, so what's important, right, is I'll share my screen again. I thought I was done with it, but I'm not quite yet. So, right, you've got this, let's just keep it on the right-hand side, the personal non-retirement side. So you've got this LLC, right? And the reason you have it is you want the law to treat that LLC as being separate from you, right? It's not me, it's my LLC. That's not my asset, it's my LLC's asset. So if you want the law to treat this entity as being separate from you from a liability standpoint, you have to treat it as being separate from you from a financial standpoint. So that LLC, people will go, well, does my LLC need a bank account? And my answer 100% of the time is yes, it needs a bank account. If it doesn't have a bank account and isn't entering into transactions, it doesn't exist, right? You might as well not have it. So it would be, right, if I was going to make an investment up into one of these syndication offerings, and I was going to do it in the name of my LLC, well, then when I put the money into the syndication deal, does that come from my bank account or my trust bank account? No, it comes from my LLC's bank account. Does that mean I can't put money, how does that money get there? The law understands that LLCs don't magically come with money in them. So you're allowed to fund the LLC with your dollars, but you have to take that extra step. You put money into the LLC bank account, the LLC shoots the money up to whoever's making the offering, and then the asset is titled, the ownership in the offering entity is made in the name of that syndication investment LLC. So the LLCs that you set up for asset protection purposes, yes, need to have their own bank accounts. They need to have their own sets of books, right? Bookkeeping. There may not be a ton of transactions, but there's going to be some, right? It's not you, it's the entity. What did the entity do? That entity also, needs to have the right sort of underlying legal documents. Can you go set up a Wyoming entity online with the state of Wyoming and get your articles of organization and your one sheet of paper? Yes. But if the rubber meets the road in a lawsuit and you have to produce your entity's documents and you just give them the one sheet of paper, the plaintiff's attorney on the other end is going to do a little happy dance because he knows that he has an in to try to get at your personal assets. Because a legitimate business entity, Your Honor, has a corporate book with membership interest certificates that show who the owners are, and it's got an operating agreement, and it has organizational minutes, and it does annual meetings. It has minutes of those meetings. And if your entity's never done any of that stuff, then that's the argument: is this thing's a sham? It's a joke, Your Honor. Let me pierce the corporate veil of this entity and get at the owner's assets to satisfy some judgment. Or there shouldn't be a charging order because this entity never did anything separately. I should just be able to get at the owner's ownership interest without having to go through the LLC that they set up.
So good. Thank you so much for sharing that. So for somebody who's wanting to set up a legal strategy, like, what are the first steps that they should take? And like, what should people start doing right now? And what should people stop doing? I know that was like 3 questions all in one, but I want to make sure we kind of start pointing people in the right direction.
Well, I would start, and this is sort of broad, but I would start thinking about these things, right? What are the legal ramifications of the investment that I'm making? What are talk to an attorney. Hey, I'm thinking about making an investment in this. First of all, they can help you with due diligence to go, wait, red flags, there's problems, number one. Number two, they should be able, if they're an attorney of the type that we are, right? If you go to a divorce attorney, they're not going to know any of this stuff, but somebody that specializes in asset protection and tax minimization and that sort of thing in estate planning, they're going to help you put together something like, hey, think about, should we do this within an entity structure? What are the pros and cons? What is it going to cost? Right? Because the cost, you got to take that into consideration too. That's why a big part of the reason people don't set up structures like this is that there's some fees, some costs involved. It's not crazy expensive, but it's certainly cheaper or more expensive than doing it in your own name. So what are the legal ramifications? Start thinking about those things and not just going, well, I'm just going to go invest. What are the worst case scenarios? So start thinking about that. And I think the first step really is, you can poke around the internet, and we have really, Mark Kohler, my boss, has a lot of really good YouTube videos that sort of get you down the path of thinking about these things. But I think the first step is to talk to an attorney who isn't going to give, in this presentation, I have to give you a disclaimer. I'm not giving you tax or legal advice. If you have a consult with me, yeah, you're my client. You're paying for time. I'm giving you tax and legal advice for your situation. So it doesn't have to be us, obviously, but we can help some attorney that you know that works in this area and that you can trust. Get some advice. Do I need to go down the route of a structure like this? What are the pros and cons? What are the costs involved? You asked like 3 questions, and I sort of answered like none of them. I hope that was somewhat helpful.
Well, no, I think, just clear steps, right? Like, it's great to educate yourself. I am all a proponent of education, but at some point in time, you need to take that education and put it into action. And that is find somebody, to talk to. And maybe you have to speak to, a couple different lawyers, 2 or 3 different lawyers, and get those recommendations from other investors.
Yeah.
That is my suggestion, because we've already touched on it. Kind of tongue-in-cheek joking, the divorce lawyer, the family lawyer isn't probably the best suited for this type of helping you think through all these different types of questions. So make sure you get somebody reputable that knows what they're doing. Have those conversations. And I know for us, and maybe I'm giving people a hall pass, it's a sliding scale. It's definitely expensive to set up this huge structure. And I shouldn't say huge, but over time, as our investing evolved, our structure evolved. As we had a kid and opened a business and opened the second business, our situation continued to evolve and continue to change, and we added to the structure.
And I would say, right, a good place to start is going back. I'll just bring it up one last time on the diagram here. Start at the bottom and work your way up, right? When's a good time to do estate planning? Before you die. right? And because nobody knows when that's going to happen, it's something that's your heirs, your kids, your siblings, your parents, whoever it is that's going to be dealing with your estate when you die, will thank you 1,000 times over if you've done some estate planning ahead of time, and they don't have to go pay attorneys to go through probate. So, you know, you can start from the bottom up. Let's do some estate planning. Let's get you a trust. All right, now I'm involved in various things, and I've got parts of my life where I feel like maybe I've got some potential liabilities out there. Then maybe we start thinking about these investment entities to provide some additional protection, both, you know, both ways, in what we call inside and outside liability protection. So it's something that you don't have to go out and get the deluxe package that's thousands of dollars to start with. In fact, I would advise usually not to do that, but start somewhere and sort of scale up as you go.
Awesome. So Jarom, you know, we're almost at time. How can people connect with you?
Oh yeah, so I'll reshare my screen. Sorry, I keep going back and forth. So I do have another slide here. So that's my contact information, you know, my email address there, jarom@kkoslawyers.com. That's our phone number. Email is that phone would be if, man, I want to set up a consult, I want to talk to Jarom for an hour, call that phone number and you can set that time up. A quick question or just sort of start the process and get more information, shooting me an email at that email address would be the way to go.
Awesome. Jarom, thank you so much for your time today. This has been amazing. Guys, I am so thankful that you took the time out of your day to not only to spend it with us here, but also invest in yourself. We're going to hang on here. If you're joining live, clean up some additional questions that are in the chat. If you're not live, we will see you next week. Thanks so much.